Overcoming a default judgment when you're sued for debt. Brought to you by Kenneth Chabert at yourlegallegup.com. Your advantage if you're being sued by debt collectors. Most debt law cases are determined by default. Default is first a court order that the defending party has failed to respond to the lawsuit within the time permitted by law. And then second, usually after some waiting period, it's a judgment which the plaintiff can use to start garnishing wages or seizing bank accounts. In general, it is much easier to persuade a court to reverse an order than a judgment. And it is also easier to persuade a court to reverse a new order or judgment than an old one. In other words, you should always remember that time is of the essence in attempting to vacate or set aside a judgment. The sooner you start trying, the better your chances of succeeding. In Missouri, for example, if you bring your motion within 30 days of the judgment, you have a much lower requirement of proof to get the order vacated. It's almost automatic. But even if you don't find out about the default judgment so soon, it's worth a shot at trying to vacate or set aside. Why is this so? Why do you have a shot at getting rid of a default? Remember that the law favors decisions on the merits of a case, that's what's really fair or just, rather than on mere technicalities. And that means if you can come up with a legitimate excuse, or even an acceptable reason for messing up, and in legalese this is called excusable neglect, plus some sort of legitimate argument that you shouldn't have to pay all or some of the judgment, then the court should let you defend yourself, and to do that it must set aside or vacate the judgment of default. Judicial policy does favor that. So now let's take a step back for just a minute and get some basic definitions straight. What is a default judgment? A default judgment, or a default, is a judgment entered by a court upon failure of the defendant to respond to a lawsuit. Anything else should not be called a default in this legal sense, although sometimes things are. If you fought the case and did something wrong, like not answering the plaintiff's discovery, and the court granted them a default as a form of sanction or punishment, this is not really a default. And your effort to change it must either be an appeal or something else, like a motion to reconsider or a motion for new trial, not a motion to set aside a default. Reasons for setting aside a default. The judgment should only be for the amount specified in the petition, that's the lawsuit. Some people decide not to defend a lawsuit based on the size of the claims against them, so expanding the amount of money after failure to respond would be unjust. If the amount is in any way different from what could have been figured out by looking at the petition, you will have a good grounds for setting it aside. It will be voidable on its face, and you should not need to show anything else, although you will have to prove that the amount is different, and then the court still might keep the default but change the amount. If you can, it's obviously better to attack the whole default. There are two main reasons people have for setting aside defaults. There was some sort of excusable behavior. They lost the summons, got lost on the way to court, were somehow disabled from going to court by illness or accident or similar basis. The other reason involves wrongful behavior on the part of the plaintiff, deceit of some sort, although this can merge into the first category. New evidence, which couldn't have been available when the suit was filed, failure to obtain proper service, or the like. Obviously, the more sympathetic your excuse, or the more blameworthy the behavior of the plaintiff, the more likely you are to have the judgment set aside. Where the reason is some sort of excusable behavior, almost all states, and possibly all of them do, require the motion to set aside be brought no later than a year of the entry of judgment. Although New York makes that after service of a copy of the judgment or a written notice of its entry. So you should check your rules of civil procedure on the question. Where the reason involves some sort of wrongful behavior by the plaintiff, the time requirement is generally more forgiving, although you should not delay. Likewise, my discussion of proof of not owing the debt probably doesn't apply. In some states, New York, again for example, the court retains power to vacate defaults far beyond the year limit if very strong justice requirements are met. But this is rare, and the courts will usually not allow you to delay unnecessarily. In general, you must show the court that your reason for not appearing in the first place was excusable in some way. If that reason is strong enough to show lack of jurisdiction, the plaintiff never served the petition on you at all, for example, then there usually isn't a time limit at all. But you must still take action to get the judgment vacated. It won't happen automatically. A second requirement where the excuse wasn't wrongdoing by the plaintiff that most courts have, at least after a certain relatively short period of time, is that you must plead facts that would be a defense to the action. I will tell you where you plead them in my video, Procedure on Moving to Set Aside a Default Judgment. A big question for motions to set aside is what facts must be alleged in the motion and what evidence is required. The answers to these questions may differ from state to state, but in general it's like this. A party seeking relief from an order or judgment on the basis of excusable default must allege facts amounting to a reasonable excuse for the failure to appear and offer some proof of them, and allege facts showing the merit of the defense. That means you just have to state the facts by affidavit in some jurisdictions that would constitute a defense. You don't have to prove them before the judgment is vacated. In your motion, you should note that an unjust ruling might subject you to multiple claims, and you should stress the importance of the policy favoring judgments on the merits rather than procedures or technicalities. Finally, you must attach the evidence to your motion. That evidence should be an affidavit, sworn statement, by you or someone else who knows from actual experience what happened and what the evidence is. As far as I know, including some evidence, at least as to the facts constituting your excuse, and possibly also of the defense, is required in every jurisdiction. But you should research your own state's requirements on this issue because they can vary. All states do follow the pattern I've described in general, but there are important differences too. You need to do some research into your state's requirements so you can get this right. Again, I will outline the specific things you will usually need to do in bringing a motion to vacate in my video, Procedure on Moving to Set Aside a Default Judgment. Protect what's yours and don't let the debt collectors rip you off. My site and materials can help. Go to yourlegallegup.com. Get my litigation manual and forms, or get the videos and defend yourself. You'll be glad that you did. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but as a former lawyer I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forms. If you appreciate this video, please take a second and like it, subscribe, and friend me, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors on Facebook or YouTube, as these things help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.